In Illinois, the most common way to eliminate your criminal history record is by expunging or sealing it. These remedies only apply when you are arrested and charged with a crime under state law. If you are prosecuted under federal law or the laws of another state, these remedies do not apply. Expungement applies to individuals who have been arrested but never convicted of a crime. The effect of expunging a record is that the information is removed from the database that's kept by the Illinois State Police, and it's as if the arrest never occurred. Sealing applies to individuals who have been convicted of a crime. Usually we're talking about nonviolent misdemeanors and a handful of nonviolent felony convictions. The effect of sealing a record, as opposed to expunging a record, is the information will not be eliminated from the Illinois State Police database, but access to it will be restricted. So that if you were to undergo a criminal background check using public record information, the information would not appear. You have a conviction record if you've pled guilty or been found guilty and received one of the following sentences: probation, conditional discharge, a fine without any additional conditions, a prison sentence, or a sentence of time served. And that would occur in the instance when you were not able to post bond and you remained in custody until your case was disposed of. If you plead guilty or are found guilty, but are sentenced to supervision or a special form of probation, either 710, 1410 probation, or task probation, you have not technically been convicted of a crime, provided that you complete the terms of your supervision or probation successfully. With a few exceptions, the majority of felony convictions are not subject to sealing. Those that are include Class 4 felonies for prostitution, possession of cannabis, or possession of a controlled substance, as well as violations involving the use or possession of methamphetamine and steroids. As of January 1, 2013, certain individuals who have nonviolent Class 3 and Class 4 felony convictions are eligible to apply for sealing if they can obtain what's called a certificate of eligibility for sealing. The certificate is issued by the Illinois Prisoner Review Board. Once you have the certificate, then you would follow the normal procedures for filing, which is to file a petition to seal with the court. In June 2013, the Illinois legislature passed House Bill 3061, which would expand the list of sealable felony convictions without the need to apply for and obtain a certificate of eligibility for sealing. It would include Class 3 and Class 4 felonies for theft, retail theft, forgery, deceptive practices, and possession of burglary tools. If Governor Quinn signs the bill into law, it would go into effect as of January 1, 2014. Certain traffic offenses will affect your eligibility to expunge or seal. They include driving under the influence, reckless driving, driving on a revoked or suspended license, or speeding in excess of 31 miles per hour. Unlike adult criminal records, juvenile records of arrests or delinquencies are not a matter of public record. They are expungible, provided that the individual has not subsequently been convicted of an adult criminal offense. Once you expunge or seal a record, you cannot be required to disclose it. The second benefit is if you are subject to a criminal background check, the information will not be found. More than 90% of employers conduct criminal background checks as part of the hiring process. Typically, an employer will make a conditional job offer conditioned on you having a clean background. If you believe in second chances, don't miss out on the opportunity to leave your past behind by removing your criminal history from public view.